Yes.
I some accommodation for item number 26. Joint player. And we are taking consent from the others.
Item number
26.
26.
Yes.
Uh, who is for the other side? Mr.
MS.
MS Hussain, Learned Counsel for the appellant, jointly with MSL Devi, Learned Counsel for the CBI, seeks accommodation for
Or 86 on the 30th.
posting this appeal on such and such date. Prayer is allowed. List accordingly.
Bathroom. Web page of item 30 from supplementary. Intermediate password for the day. In this case, argument counsel is out of station.
Your name?
AK Azad.
Mr. A.K. Ajad. Your name is A.K. Ajad.
My lord.
Your name is Ajad. Mr.
My name is AK Azad.
Mr. A.K. Ajad, Learned Counsel for the petitioner submits that Mr. Auddin is out. Jiuddin, the arguing counsel, is out of station and accordingly seeks adjournment. Prayer is not opposed. List after 2 weeks. Did you list 3 weeks or so on such and such date after?
First of item number 27.
27.
27. We have 3 for an enrollment. I need to seek certain instructions from my client.
You are Mr. Uh, Mr. A.R. Bora seeks accommodation for
After verification.
for a week, which is not opposed by the other side. Consent taken or not? Prayer is allowed. List after vacation date on such and such day. Yes.
Lordship, I beg to mention item number 13 and 14, Lordship. May I adjourn this matter for the day, Lordship?
13 and 14.
13 and 14, Lordship.
Motion matter. No, it's a motion matter. Why?
Lordship, my senior is out of the station, Lordship.
Well, it will come after the vacation. They are not in a hurry, Mr. Parasar. You are for the petitioner.
Lordship.
As item 13 and 14.
14.
But both are separate matters.
Same matter, Lordship.
Belek beleke di diba, Tutate di diba. As prayed for by MS.
He does.
B does list detail after 4 weeks at that date on such and such date.
Your Lordship, I beg to mention for item number 16, Your Lordship. This matter was earlier disposed of by the Honorable Justice P.J. Soika, Your Lordship. Kindly matter may be listed in the said bench.
No, but it's a motion matter. File to file. You wait. Let the matter be called. Mr. Parasar, just have a look. Is it a motion matter? Is it a part-heard matter?
No, not part matter. Earlier, it is bill by the
Oh, fine.
I annex the order copy, Your Lordship. Kindly see the page number 32. 16.
motion.
The fresh matter. Challenging what? Quashing in orders.
It's not there.
Why this matter has to go before a particular judge? We'll forget to find it there.
It is not a
Please see why this prayer has been made.
I have the copy, but
How can such prayer be made? You have filed to deduction.
I
See. First time,
last time it is not a bail petition. Only female petition, once disposed of by earlier justice. Otherwise,
so then
it is not bar. Bail.
is there a bar for this court to take up this matter?
regarding bail, only bail.
It's not your fault. Uh, you wait for your turn, huh? In the meantime, I'm going to take up 16 after the motion matters are over. So you wait.
I have not the draft, your lordship.
That is your problem. Next,
Obliged.
if you are not here, I'm going to dismiss it. So you wait when the matter is called. Yes.
Makes this a lordship, I'm paying for an accommodation in with regard to item number 22, lordship.
22.
His lordship, maybe after vacation, lordship.
All right.
M. Nirola.
As prayed for by MSN and Nirula, then it counts M or N?
M. lordship.
M, right? M for Madhya Pradesh. M. Nirula, Leonard Council for the appellant, relist date deliver in the month of May.
Obliged. High.
Item number 1.
এবার খবর লইল কারণ অনুপাত প্রেয়ার is unusual, no? Order to খবর তো দিব আর তারপরে প্রসিডিং বা আসেন Yes, Mr. Dev,
Yes, Lord.
what is this?
What has
Criminal
happened in this
petition.
case? This is a case under the DB Act. The petitioner before lordship is the brother of the husband of the aggrieved person. The husband is a person of unsound mind.
Hmm?
He's a person of unsound mind. Now, in the written statement, we took a plea that he is unsound. Thereafter, we filed an application under 329/30, saying that it was filed by the elder brother, that he is a person of unsound mind. He is not in a position to understand the proceeding. That application was rejected on the ground that this is a quasi-civil proceeding and the CRPC, provisions of CRPC is not applicable. Now, lordship, if you look on lordship, kindly comes to the DB Act.
Before that, let us see the impugned order. 29/6/2024.
Yes,
Which
29,
page?
page 80.
Yes.
The lordship may, the aggrieved person is represented by her learned counsel. The respondents are absent with step by number so and so. I pray for being allowed to be represented by the learned counsel for today. Today, the date is fixed for orders of petition number so and so, which is it was submitted as the respondent number 1 is suffering from bipolar disorder, into which is presently is not in a position to understand the legal proceeding in the instant case. As such, the respondents paid for proceeding with the instant case as per the procedure laid down in section 329, 330 CRPC. The aggrieved person paid for dismissal of the instant petition on the ground that the same was filed by the respondent with malified intention in order to deprive the aggrieved person from a lawful entry. Heard both sides on petition number so and so. It is pertinent to mention that a judicial magistrate, while dealing with a DIR or an application under section 12 of the protection of women and so and so, not has any power to either convict or acquit the respondents after conclusion of the proceeding. A domestic incident report or an application under the Protection of Women for Domestic Violence Act is filed before the judicial
What
magistrate.
is wrong, this order?
I'll just take a minute. Thereafter, within whose jurisdiction the domestic violence has been committed or the victim lives. But in the facts of the objects and reasons of the penal, so the phenomenon of domestic violence is widely prevalent, but has remained largely invisible in the public domain. Presently, where a woman is subjected to cruelty by her husband or his relative, it is an offense under section 498A of the Indian Penal Code. It was therefore proposed to enact a law keeping in view the rights guaranteed under Article 14, 15, and 21 of the Constitution of India to provide a remedy under the civil law, which is intended to protect the woman from victimized in connection with domestic violence and to prevent the occurrence of domestic violence in the society. Thus, even a casual reading of the objects would make it clear that the proceedings under the PWDB Act was a quasi-civil in nature and not criminal. As such, this court is not inclined to invoke the criminal law as prescribed under section 329 CRPC. Once it is quasi, it becomes quasi-criminal also. Now, lordship will kindly take the DB Act for a moment.
This matter will need some examination.
So exactly, now if a person who is of unsound mind, who is unable to understand the proceeding,
I'll issue notice, but stay of
so
the
because because the petition was filed, because lordship I can just point out from the written statement itself. Now, lordship,
order is dated
it
29/6.
was listed earlier, in fact,
You have come late also.
no, immediately, lordship will see There is already it was initially listed before-
29 June 24. And
it
when
was
did you
initially
file?
listed before, Justice Nandi Milord. Thereafter, Milord, I made a
No,
mention,
but, on that date, well, on your prayer, the matter
Yes,
was, that
that is true.
is in the
But it
month
was
of
heard, it was
October.
heard and lang, Milord, thereafter it was fixed, Milord. I made a mention number of
That
times.
we don't know, but you have filed it on 27 September. Order is of 29 June.
True, Milord. So within the period of limitation, but that is,
So I'll post it after the vacation. You
The only thing,
and keep the interim open.
the only thing, Milord, if the proceeding is tomorrow. Milord. But if your lordship, I'll just take you to, Milord,
That's
this,
how the matter is listed today.
like, I'm not aware, Milord, because
Anyway, but let's not get into all this.
only thing, Milord, I'll just.
You may,
I'll just,
you
Milord, I just
may
pointed one
inform
thing.
that the matter is posted on the
Milord, I just,
after
I
reopening.
I'll point out one
But,
thing.
I
I
want
understand.
to
I
stay
just
the
point out one
criminal
thing.
proceedings.
Lordship,
No.
section 28 of the below DV Act, Milord.
Yeah.
Save as others covered in this act, proceedings under section 12, 18, 19, 20, 21, 22, and 23. And
Had
offenses under
had you approached it immediately, it could have been another thing. Sorry. And you see, from third October 2024, the matter hasn't moved.
in fact, I had made mentions, Milord, but that was
There's
not.
no
listed for-
mention memo here.
I have made mentions, Milord. In fact,
Anyway, Mr. Dev, not today. Heard Mr. R. Dey, Learned Counsel for the revision petitioner. Also, your state is there? No. This is an application under section 438, read with section 442 of the BNSS 2023, seeking quashing of the proceedings of Miss within bracket DV case number 223/2020. Quashing of the proceeding or that
no,
order?
no, that order, Milord. I
Sorry,
just want the inquiry under 329.
Seeking quashing of the order dated 29/6/2024, passed by the Judicial Magistrate First Class Kamruk M at Guwahati. Inter alia Koilwa. Issue notice returnable. Give a date after vacation. Register post. Do you want to take Dusty as well?
That's the, I think, in fact, the date is tomorrow, so I'll be.
On such and such date and note steps by registered post as well as Dusty. List
Entry will be considered on the next.
and interim prayer shall be considered on the next date.
May I plead the law?
Yes,
My lord, this revision is against the judgment of law, land and law appellate court, my lord. There was,
amended cost title you have submitted.
my lord,
Amended cost titles have been submitted.
yes, my lord.
Submitted.
So I think last order, by last order, 10 copy was called for. Don't know.
One sec. Let me first see whether the amended cost title has been given or not. I'm not sure if the amended okay, it has been to submitted on 20th March 25. And which order scan copy? I said
2019, 24, my lord, written in our petition, my lord.
Hmm?
Your my lord. Judgment by the land and law appellate court, my lord, page 27.
I don't see any scan copy being
My
called.
lord, my lord,
You need it. Yes. Notice is still not issued.
my lord.
Notice is still not issued.
No.
Which order is under challenge?
My lord, the judgment, interim judgment of the land and law appellate court, my lord, it starts at page 24, my lord. 27,
Operating part
27, my lord.
27 it starts.
27, my lord. Annexure 2. Judgment of the land additional session judge, my lord.
This is appeal. The appellate court appears to have considered everything. I will issue notice at this stage, nothing more than that. Uh, Heard Mr. M.H. Raj Barbhuya.
Yes.
Learned counsel for the petitioner, also heard Mr. K.K. Parashar, learned APP for the state respondent. This revision petition is directed against the judgment and order dated 22/8/2024, passed in criminal appeal number 224 of 2017, passed by the additional session judge number 1 Kamrup M. Guwahati, whereby the appeal filed by the informant for convicting all the 3 accused persons against the judgment passed by Learned Additional CJM Kamrup M. was allowed,
No, appeal was partly allowed, my lord.
was partly allowed. Stop. Issue notice returnable 3 weeks. Mr. So-and-so accept copy for respondent number 1, extra copies within 3 days, registered post AD in respect of R2 steps 3 days. List after returnable kiman disla 3 weeks on a date to be fixed by the registrar.
My lord, I make a prayer for the stay of the interim.
Interim prayer shall be considered on the next date of listing. 10 copies would be required.
Can original record come, my lord, because appeal already completed, my lord.
So I'll call for it. Let the TCR be called for through the registry of this
Applied. May I please,
interim order after receipt of TCR. Yes.
may I please, your lordship. Lordship, this is 5.8 petition, your lordship, challenging the order dated 23/9/24, your lordship, passed in FC criminal case number 175/24. The impinged order is at page 15, your lordship. Your lordship, by this order, your lordship, the interim maintenance was passed by the honorable family court, your lordship, amounting 10,000
Page
page 15, your lordship.
15. Yes.
Lordship, by this order, your lordship, interim maintenance was passed against the petitioner for the petitioner in FC criminal and her minor daughter, your lordship, amounting 10,000 per month, your lordship. So, your lordship, at this stage, my humble prayer is, your lordship, notice may be issued and the interim maintenance may be reduced up to 5,000, your lordship.
No. Not reduced, but your prayer for reducing will be considered on the next day. Heard Mr.
IH President.
MD IS Laskar, Laskar, na?
Yes, sir.
Laskar, Learned Counsel for the petitioner. Top. Also, any PP is there?
No.
This is an application under section 528 of the BNSS 2023, read with section 19 within bracket 4 of the Family Courts Act 1984, seeking quashing of the order dated 23/9/2024, passed by the Principal Judge, Family Court number 2, Kamrup M, in FC criminal case number 175/2024, whereby the petitioner was directed to pay a monthly interior maintenance of rupees 10,000 to the opposite party and the minor daughter till the disposal of the case on merit. So, issue notice returnable 3 weeks, steps by registered post AD within a period of 3 days from today. The interim prayer to the effect of reducing the interim maintenance of rupees 10,000 to rupees 5,000 shall be considered after the appearance of the respondent.
I do.
May I please, your lordship. Lordship is an application under section 447 of the BNSS 2023, lordship, seeking the transfer of the NI case 54.
Transfer.
Yes, sir.
All right, notice.
Notice, fine.
Heard Mr.
NJ Daimari.
N.
NJ
J.
Daimari.
Daimari, Learned Counsel for the petitioner. Also heard K.K. Parashar, Learned APP for the state. This is an application under section, this is a transfer application for the transfer of the NI case number 54/2024 pending before the JMFC 1 Sibsagar Assam to where?
Kamrup Metrology. CGM Kamrup Metrology.
All right, Basimane Nikiti. Issue notice, returnable 3 weeks. So and so accepts for R1, registered post AD for R2. List after 2 weeks and a date to be fixed by the registrar.
Obliged.
So it will be taken after some time.
All right,
This time won't be.
After some time.
I'd like to draw your lordship attention to the order dated of your.
One second. Yes, please.
I'd like to draw your lordship attention to the order dated 28/2 of 2025. The lordship was please to grant some time with respect to our prayer in this petition. In this petition, at the first para,
Yes.
what Mr. So the learned counsel for the petitioner who fairly submits that though this criminal petition lacks merit. However, considering the circumstances in which the condonation of delay application filed by the petitioner before the court of the learned additional session judge, Nagaon, which apparently shows that there was a mistake on the part of the engaged counsel is in drafting the condonation of delay application properly. He submits that inherent power of this court may be exercised to allow the petitioner to file a fresh condonation of delay application before the revisional court below, again for the ends of justice. So the time was granted to find some authority. In my respectful submission, we couldn't find any authorities of the Supreme Court, neither of the Honorable High Court. So I leave that to your lordship mercy. So this is a case where ex parte maintenance was allowed, the respondent. And thereafter, during the execution was also allowed and a distress warrant was issued, which
Where is the impugn order?
impugn order is in 63. If I may read
Yes, please.
from the second para.
Yes, please.
Applicant contends that he was the second party and the opposite party was the first party before the learned trial court in MR so and so under section 125 CRPC. That orders dated so and so and ex parte order dated 17/9/2016 were passed by learned trial court behind his back. The applicant came to know about the MR case when he was posted at Lakhimpur in the month of February 2023. When the superintendent of police Lakhimpur sought from him one photocopy of voter ID card without explaining the cause. The applicant on 10/3/2023 came to know from a reliable staff of SP office that an amount of rupees 6,500 is being deducted from his salary every month through court. At no point of time, second party applicant was served with any notice in connection with MR case so and so. Learned court did not examine the process server. Service report is neither supported by any affidavit nor it is prepared in presence of two witnesses. As the second party is an ordinary keypad mobile user, he was not unaware of any deduction from his salary. He came to Nagaon Court, one counsel procured relevant case record and having viewed certified copies, second party became shocked that a female stranger not connected with his matrimonial personal life had instituted said so and so case against him, claiming herself to be his wife and claiming her son to be his. He came to know that on the strength of order dated 17/9/2016, in the MR case, he has been directed to pay rupees 45,000 per month as maintenance to the first party and another amount of 2,000 per month as maintenance to her son till his majority. Hence, this prayer to condone the delay in preferring the revision, challenging the legality, proprietary, aforesaid impugn orders and judgment. One is the observations in the next paragraph. The result of the case record shows that the MR case number so and so.
So basically in that MR case, he did not get notice according to
Yes.
the facts.
In the execution also, the notice was not served, and after getting the certified copies, it was seen that the notice was accepted through WhatsApp. So
Okay. Then,
thereafter, I wasn't aware that from September 2022, as per the order, my salary was deducted.
all right, you read perusal.
perusal of the case record shows that the MR so and so was decided ex parte on 17/9/2016, and the orders and subsequent orders are towards execution of same. Order dated 16/5/2023 shows issuance of BWA against the second party. On 3/6/2023, prayer for condonation of delay in preferring revision has been registered at the instance of the second party. Article 131 Indian Limitation Act provides for 90 days from the date of decree or order or sentence sought to be revised. Perusal of the case record shows that petition registered on 3/6 which seeks to condone the delay in preferring revision against order dated 17/9/2016. In view of Section 3 Indian Limitation Act, it is preemptory and each court is bound to see whether claim is barred, but in light whether rider provided under Section 4 to 24 of the Act comes to the rescue of the applicant. Section 5 of the Limitation Act provides for sufficient cause if the applicant satisfies court of law that there was a genuine reason for not knocking the door of court within the time stipulated by law. What is next para? Sufficient cause is an elastic term and depends on facts and circumstances of each and every case. In this case, applicant avers that service report shows his refusal to accept notice on 31/8/2018 in MR so and so case, but said service report is neither supported by affidavit nor bears sign of two witnesses. Again, the applicant, having only keypad mobile, was also unaware of the deduction from his salary. But conspicuously, the wordings of the para 9 of his petition shows that the applicant did not mention when he came to know about the unfortunate and untoward happening. Notably, he avers that it took place behind his back. It is contended that he came to Nagaon court and on instruction of an advocate obtained certified copy and came to know that by final order, he has been directed to pay 4,500 and 2,000 to her son and to his wife, first party, and his son till his attaining majority. Hello, next para. Again, it is averred by para number 5 that Superintendent of Police Lakhimpur once asked for his photocopy of the voter ID in February 2023 when the applicant was posted at Lakhimpur. But SP concerned never explained to him the reason. In March 2023, from reliable staff of SP office, he came to know that rupees 6,500 is being deducted from his salary. Here again, by para number 6 of the petition, date of his coming to knowledge with effect from which his salary has been diverse to have been deducted is conspicuously missing. These being the reasons to condone his delay in preferring the revision when this court scrutinized the case record, including that of the Honorable Trial Court, it appears that order passed by the Learned Trial Court on 30/8/2022, deducting the monthly maintenance order and issued notice to DDO of the second party. This court is not convinced with the reason that the applicant was not aware of monthly deduction from his account, that too when the sum is rupees 6,500, which is not a meager amount. At this junction, that by para number 10 of the application, the revision is denied marriage with the opposite party and also disowns that he is the father of the son, to whom maintenance allowed by the lower trial court, by the learned lower court. Learned counsel R. Ullah submitted during a printout of criminal petition so and so under section 482 CRPC, drawing attention of this court that the revision is already paid rupees 50,000 out of the arrear amount of rupees 4,24,000, and honorable court directed him to pay the balance amount.
I have read it. You are Mr.
N. Patiri.
Patiri, Mr. Patiri, at page 67, what is this revision petition that has been referred here?
This is the warrant of distress warrant of arrest was issued, my lord, in the execution case. Thereafter, as I was not
And in that you had submitted, you had already paid rupees 50,000.
during the pendency of that proceeding, my lord, the order is
If she is not your wife, why did you pay?
I didn't get a chance to challenge it. That is my
Patiri, you see, first of all, this is the power to condone is a discretionary power.
Madam.
The court has already exercised it, the
Madam.
appellate court, right? Has
revisional.
revisional court has already exercised its jurisdiction. Refused it because the revisional court is of the opinion that no sufficient cause has been shown.
Madam.
You have
But,
not explained, and it appears your conduct.
Madam, the conduct.
You see, conduct is very important. Before the High Court during at the time of that criminal revision where you have challenged the warrant of arrest,
Warrant of arrest.
you
That was
have
out of the-
submitted.
Madam,
that, para 3, read page 70.
Page 70. Mr. Bora, that, order dated passed in, yes, my lord, that is
Please read.
it is submitted, para 3, my lord.
Yes, please.
It is submitted by the learned counsel for the petitioner, Mr. So that in pursuant to the judgment and order dated 17/9/2016, passed in MR case number so, the petitioner is paying 6,500 only as maintenance allowance to the respondent as directed by the learned trial court. Though some area maintenance is yet to be paid to the said respondent number 2 till date, and since the month of December 2023, the monthly maintenance of rupees 6,500 only has been directly transferred to the account of the respondent number 2 from the salary account of the accused. But due to non-payment of area maintenance of rupees 4,55,000, the SDJM Nogam issued the distress warrant against the accused petitioner, and on non-execution of DW, the learned trial court issued bailable warrant of arrest against the accused. The learned trial court issued the bailable warrant of arrest on 9/2/2023, fixing next date as 9/3/2023, and on the subsequent dates, also the learned SDJM reissued the bailable warrant against the present petition. Thereafter, it has been observed by the learned trial court that the petitioner neither appeared nor deposited the amount towards the maintenance, and accordingly, by order dated 14/7/2023, the said court issued the warrant of arrest, fixing the date 24/8/2023 on the subsequent date. Also, the NBWA was issued against him by the trial court.
Para 4.
He further submitted that the petitioner is regularly paying his monthly maintenance as per the order of learned SDJM. Although there are some area prior to December 2023, however, the petitioner is ready and willing to pay the area maintenance to the respondent number 2 in installment basis. But because of issuance of warrant of arrest, the petitioner is under apprehension of arrest, and hence he could not appear before the learned trial court for the payment of the remaining area maintenance allowance. Accordingly, prayer was made for recalling of the NBWA issued against the accused, giving him an opportunity to appear before the learned trial court to make the payment in installments. So that is the
And then 5.
fine. He further submitted a fine order dated 12/3/2024. This court asked the present petitioner for payment of rupees 50,000 only towards the area maintenance amount, and complying the said order, he already paid rupees 50,000 towards the maintenance area, and warrant issued against him has been recalled by the learned trial court. The
Further,
further is
This is
ready.
very important.
Further, the accused is ready and willing to pay the remaining amount of area in installment basis. Plus, there is a
And let's continue reading. Yes.
paragraph 6. In this regard, Mr. Nawaz, learned counsel for the respondent number 2, has submitted that rupees 50,000 only has already been received towards the area amount. However, the total area amount due is 4,74,000, and out of which rupees 50,000 only has already been paid in pursuant to this order dated 12/3/2024, and there is still balance amount of rupees 4,24,000 only towards the area maintenance. He also submitted that he has no objection in disposing of the present criminal petition. However, a necessary direction may be given to the petitioner for payment of the balance amount, area amount in installment basis within a stipulated period of time. Considering the submissions made by the learned counsel for both sides upon perusal of the case record, it is seen that petitioner has already paid a sum of rupees 50,000 only towards the maintenance allowance, on the basis of which the warrant of arrest was recalled. More so, the petitioner is also ready and willing to pay the balance area amount in installment basis to the respondent
Hey,
number.
this is dangerous.
Well,
You cannot keep on changing your stand before
Hello.
the forum as convenient to you. Before this high court, at that point of time, what was important for you is to get those NBWA
I go down to your lordship.
set aside. You said you are already paying, you are ready to pay the entire balance 4,24,000 in installments. Based on such assurances, the court has ultimately set aside those orders. And then you go and file another revision, which is grossly delayed.
Well,
That now gets
this is the conduct
may-
bylaws of the,
and you are before a discretionary court. If this is your conduct, what is wrong in the order of the trial court, the revisional court dismissing your revision?
Well,
What is wrong?
there is,
Conduct
it has been decided on merit.
In fact, if you go on arguing, I'm sorry, I'm going to dismiss it with cost. It looks like you're abusing the court process.
Well,
This is not the way.
well, the- this-
Before the high court, you take one step. Today you are taking the stand, no, I don't even know this lady. She's not even my wife.
That
The
was
child
taken-
is not my. What kind of all this stand when it appears you've been paying and you were ready to pay the remaining 4,24,000? Why these stands were not taken before the High Court?
Manoj, this is my only submit, whatever the instruction is there. It was out of the fear and apprehension of the
You
arrest.
see, Mr. Counsel, if this court starts acting on such kind of submissions which has
Yeah,
no
but-
backing, what will happen then?
Manoj, that's why on the first day itself, we had made a submission that petition lacks merit.
No, not only that, it appears that you are taking different stands before as convenient to
I don't-
you before the High Court. In the earlier round, you had specifically taken given your assurance to pay the maintenance, and now you are saying, no, she's not my wife.
Manoj, that was taken in the revisional code also, you know. That is the on merit, my lord. That was not decided. And the revision was filed before coming to this honorable.
Anyway, I've heard. You want to add something?
Because he has taken, earlier he has taken this 10 also.
Uh,
He has consented.
Heard Mr. N. Patiri, learned counsel for the petitioner. Also heard Mr. Parashar or you? Yes, law firm, learned APP for the state respondent. This petition is under section 528 of the BNSS 2023, seeking quashing and setting aside of the orders dated 8/7/2024, passed in criminal within bracket L 7/2023 by the learned additional session judge number 3, Nagaon, whereby the petition filed by the petitioner for condoning the delay in filing the criminal revision was dismissed. The facts of the case is that, the brief facts of the case is that the respondent number 2 had filed an application under section 125 CRPC against the petitioner in the month of April 2015 before the court of the learned Chief Judicial Magistrate Nagaon, which was later on transferred to the court of learned Subdivisional Judicial Magistrate Nagaon for disposal. Thereafter, since the petitioner did not appear before the court, before the magistrate court, the magistrate court proceeded ex parte against the petitioner, and on 17/9/2016 was pleased to direct the petitioner to pay an amount of rupees 4,500 only to the respondent number 2 and rupees 2,000 only to the son of the respondent number 2. Minor son, huh?
Minors on that thing.
Minor son.
He has 18 majority now.
Thereafter, the order dated 17/9/2016 could not be executed due to the absence of the petitioner Stop. Situated thus, the respondent number 2 on 6/9/2021 filed a petition before the trial court for revival of the said case, and the trial court by order dated 18/9/2021 was pleased to revive the said case and issue notice to the petitioner. It appears that it is the further case of the petitioner that though notice was issued against the petitioner, however, it was not duly served upon him, and as such, the petitioner was absent on 21/10/2021, 22/12/2021, and 22/20. Thereafter, the respondent number 2 filed a petition on 22/11/2021, seeking the respondent number 2 be allowed to issue notice upon the petitioner through the WhatsApp messenger, and the learned trial court was pleased to allow the same. It appears that on 23/12/2021, a report was received from the process server of the court regarding the service of the notice upon the petitioner through WhatsApp, and the case was posted on 27/1/2022. Thereafter, on 27/1/2022, since the petitioner did not appear, the trial court was pleased to issue a distress warrant against the petitioner. Thereafter, on 24/2/2022, 24/3/2022, 13/5/2022, 27/6/2022, and 28/7/2022, the distress warrant were unable to be executed against the petitioner. Accordingly, on 28/7/2022, the respondent number 2 filed another petition for deducting the monthly allowance from the salary of the petitioner, and the learned trial court by order dated 30/8/2022 was pleased to direct the drawing and disbursing officer of the petitioner to deduct an amount of rupees 4,500 for the respondent number 2 and 2,000 only for the son of the respondent number 2. Thereafter, on 31/10/2022, the petitioner the respondent number 2 filed a petition before the trial court stating that as per the order dated 30/8/2022, the respondent number 2 received an amount of rupees 6,500. However, there is an arrear amount of rupees 4,61,500, and accordingly prayed for issuance of the distress warrant against the petitioner. Thereafter, the trial court issued a bailable warrant of rupees 10,000 by order dated, which order? By order dated 9/2/2023. By order dated 9/2/2023 against the petitioner. It is the specific case of the petitioner that after the petitioner came to know the deduction of an amount of rupees 6,500 only per month from his salary, he preferred a petition for condonation of delay for filing a criminal revision before the court of the Additional Session Judge Nagaon against the ex-party order dated 17/9/2016 passed by the magistrate court and all the previous and all the subsequent orders. I think 17/9 is the first order
79, 2016 is the final order of maintenance.
and all subsequent orders. Thereafter, the learned additional session judge was pleased to dismiss the said criminal L petition 7/2023 for lack of proper explanation. Situated thus, the present revision petition has been filed. Mr. So-and-so, learned counsel for the petitioner, submits that the respondent number 2 is not the wife of the is not the married wife of the petitioner, and the minor son, which she claims to be his son, is also which she claims to be born out of their wedlock, is also not correct. He further submits that the petitioner does not know respondent number 2, and it is only when the salaries was deducted from his account he had come to know about the maintenance, about the impugned order of maintenance. He accordingly submits that the order of the trial court, order of the revisional court dismissing the delay condonation application warrants interference from this court. Per contra, so-and-so APP submits by vehemently opposing the prayer made in the criminal petition, submits that the order of the revisional court dismissing the condonation application on the ground of lack of proper explanation for delay warrants no interference from this court. Heard, perused. App 2. Where is that order?
The Honorable High Court's order.
No, the order of whereby the delay was the impugned order here.
Impugned order is at
It starts at 63.
63.
The app to refer to the impugned order dated 8/7/2024
8/7/20.
of the revisional court, which reads as hereunder, quote unquote. A to A, huh? Didiba, pura didiba. From page 63 to 68. Perusal of the aforesaid order, it is apparent that the revision court apparent that no sufficient explanation was given in the delay application for the delay that has occurred in filing the revision petition. That apart, it appears that against the orders of the magistrate court, whereby the warrant of arrest was issued against the petitioner, number 272 of 2024, wherein the petitioner had assured before the court that he is ready and willing to pay the area maintenance to the respondent number 2 in installment basis. Balance area amount. Huh? Relevant paragraph of the judgment and order dated 21/5/2024 of this court is reproduced here under for ready reference. Paragraph 3, page 70 for our camera. Eight or like para 8. Reading of the aforesaid judgment, it is apparent that this court set aside the orders of the magistrate court, set aside the warrant of arrest issued by the magistrate court on the basis of the assurance made by the petitioner that he is ready and willing to pay the balance area amount in installment basis to the respondent number 2. It is also apparent that out of the total area amount, 4,74,000, a sum of rupees 50,000 has already been paid in terms of this court's order dated 12/3/2024 during the pendency of the said criminal revision petition. And there was a balance of rupees 4,24,000, which the petitioner assured before this court in criminal petition number 272 of 2024 that the same shall be paid in installment basis. Today, Mr. So-and-so, learned counsel for the petitioner, submitted before this court that the petitioner does not know the respondent number 2 and she is not his married wife. It appears that the petitioner is taking contrary stand before this court as per convenience. Such conduct of the petitioner is clear indication, such conduct of the petitioner is total abuse of the court process and no relief whatsoever can be given on the basis of such frivolous petitions. Be that as it may, as stated above, this court does not find any legal infirmity in the order of the revision court dated 8/7/2024, and as such, the petition fails, dismissed, no cost. Sorry. Yes.
I'm with.
Why was this kept time being?
Some junior had mentioned.
Where is he now? Huh? कोई बोले मारी नहीं तो emotion की हेक होलो बढ़िया.
May it please your lordship.
Yes.
Lordship, this petitioner, your lordship, he is pursuing a course.
Hmm?
That
Pursuing a course.
Pursuing a course, your lordship, that is Amity University as Bachelor of Visual Arts, that is cinematography, your lordship. So he is permanent resident of Moscow.
What is under challenge here?
Telling your lordship, they taking cognizance of the offense, your lordship, where there is no material set on your lordship, that there is any allegation of race and negligent driving.
So the cognizance order is under challenge.
I have told the as well as the entire proceeding I have said.
Where is the cognizance order?
Lordship, that is at page. At page, your lordship, it is 70, your lordship.
70?
70, your lordship. Relevant portion is your lordship 72.
Where is the charge sheet?
Search it, your lordship, at page 35, your lordship. Relevant page is 41.
Page
Page 41.
35.
41, your lordship. 41. For one, your lordship, there is no eyewitness, your lord, to the incident that there is any race and negligent damage. May I,
Yes, please read. During the investigation,
lordship,
read during the investigation.
investigate your lordship on 2023. Informant Amida Begum.
Read during the investigation. Read.
Page 41 of the. Page 41.
41, no, no.
41.
41, eh? Yes, your lordship. On 9/3/2023, the informant Abhidagam wife also. During the investigation.
You read.
The
Please
place
allow
of-
your junior to read. Read from that during the investigation. Let her read and then you submit. Read.
During the investigation, the place of occurrence was inspected and the statements of the witnesses were recorded. Since the case has been well established against accused Arafat Imtiaz, son of Imtiaz Ali,
So and so.
Kumarpara, so and so, under section 279/304A of IPC, I have submitted this charge sheet to the Honorable Court under the aforementioned sections of law. A Caesar list, a MPI report, a bail bond, an inquest report, a postmortem report, a sketch map, and a GDE extract copy are enclosed herewith. The witnesses named in column 12(1) will substantiate the case.
All right. Now, where is the FIR?
Very at page 30, your lord.
Yes, please read.
30, your lordship.
Yes.
The Your lordship, it is dated 9/3/2023. Sir, the above name informed by state that at around 6:30 a.m. on 4/3/2023, while her husband Moghrab Ali was crossing the road at Tamul Goli near Fancy Bazaar, the driver of the aforementioned motorcycle was riding that motorcycle at a high speed and in a negligent manner hit him with front wheel of it from behind. As a result, Moghrab Ali was thrown to the ground, suffering a severe head injury along with multiple injuries to various parts of his body.
Means what is your round of challenge of the cognizance? There are materials. Now, whether eyewitnesses have seen, not seen, these are matter for trial. They cannot be decided at the stage of taking cognizance. Cognizance is not a mini trial. There has to be some material.
Cognizance must be based on facts, your lordship.
Facts they have read. These
Yes,
are
fact.
there are
And
evidences.
and
Only notice at this stage, nothing more.
your lordship, just 1 minute, your lordship.
I'm
She is
issuing
not an
notice.
eyewitness. She is not an eyewitness.
These are things which has to be
See,
decided at the trial, Mr. Ali,
Your-
not at the stage of cognizance.
lordship,
Anyway, I am
I'll
issuing notice.
convince your lordship. I'll convince your lordship. All accident does not mean, your lordship, that there is negligence, there is race.
Yes,
Mr.
very very
Coun-
less
Race and
serious, Lordship.
negligence, your
Mr.
lordship.
Counsel,
It
you
cannot-
want the cognizance court to hold a mini trial and
Yes,
decide whether there is
lordship,
rash negligence, evident or not evident?
Lordship, he made a claim before the
Sorry.
MSCT court. MSCT court,
You want a
lordship-
dismissal or you want a notice?
lordship, in that case,
I
will
don't
give-
find any merit.
Your lordship, I will give it 2 weeks time, your lordship. I'll convince your lordship. 2 weeks time.
I'm issuing notice and interim on the next day.
But because
Heard Mr. S. Ali,
They
learned
made a
counsel
claim,
for the
your
petitioner.
lordship.
Mr.
Your lordship.
Counsel, please hear
Lordship.
the order.
kindly lordship, they made a claim before the MSCT court, your lordship, and they have
As
been
paid
given
list
notice,
after
your
2
lordship.
weeks.
They have been given, your lordship.
Next
till the-
case.
Number 8.
Yes. Yes, Ms. Som, what is the challenge?
Final challenge is against the justice foreign. Actually, before that, can I place the fact once for later placement of the case? Fact is that lordship, the respondent herein deserted the petitioner. And finding no other alternative, petitioner had to file a divorce case. And the trial court convincing that yes, he has deserted the petitioner. The decree of divorce has been granted in favor of the petitioner. At the same time, lordship, petitioner, while in this proceeding, petitioner filed a maintenance case, wherein the honorable court passed an order for 3,000 initially. Thereafter, she filed again a petition for enhancement of the same. Now, court has enhanced it to 5,000.
From?
Thereafter,
From?
3,000 to 5,000.
So this is
Then-
what you are challenging?
No, lordship, that is not my challenge. Thereafter, lordship, because I am a poor teacher, I came before this honorable court saying that I cannot pay 5,000, let me pay 3,000. And till today, I'm paying that. Even the distress warrant will disclose that I'm paying. That is one point. Thereafter, lordship, what happened? After the divorce is over, every proceeding, she has again come up before the trial court with a petition of alimony, say under section 25 of the Family Court Act, alimony. Now again, I was called in the proceeding. I participated. I filed my objection. Then, lordship, the honorable trial court has passed a alimony passed is even with the maintenance order of 3,000. Now again passed an order of 4 lakhs something to be paid by the 5 lakhs to be paid by the petitioner. So being aggrieved with that, case, in the meantime, Lordship, that 5,000 order, I have challenged before this honorable court. This honorable court has, court allowed me to pay 3,000 per month. So that is still now, that is continuing. So meanwhile, that order for alumni, permanent alumni, where earlier court has not adopted that issue. Subsequently, again, being agreed by that order, we have filed another application challenging that order in the court. In that proceeding, Lordship, that is passed on 3/9/2024, we have challenged before this honorable court by filing a MAT appeal. And in the MAT appeal, notice has been issued, and that is sub judice. Now, thereafter, Lordship, that order has been duly communicated because we were asked to take steps on the respondent. That order was duly communicated, and that is well knowledge within the court below. That that matter has become sub judice now. Now the impugned order has come, Lordship. Lordship would be pleased to find that on 13/3/2025. May I read the contents, Lordship?
Yes.
Yes, first party is present. Learned advocate for the second party has deposited 3,000 towards maintenance of the first party, which is duly received by first party. Learned advocate for the first party by petition number so and so submitted that second party has a huge amount of arrears to be paid in the first party, which is willfully not paid by the first party, paid to against second party, hard considering above issue distress warrant
Something is
against the second
missing
party.
and prayed to issue. Okay.
Yes, Lordship. So, Lordship, accordingly, this is distress. Now, I am agreed by this order, Lordship. My prayer is that till he is not a party here, Lordship. Only this only prayer.
Now, what happens?
He is the only
Has
party.
he provoked
He's
you
not-
by any means?
No, I'm just telling.
Yes.
Lordship, my only submission here, I'm paying the 3,000 Lordship. I'm a poor school teacher. Till that, whether I'm payable, I'm to pay by because this now, this matter is pending before this. honorable court.
Where? Which, in
Yes,
which page?
Lordship, I'm placing that,
26.
page 39. It is, 36 Lordship. Mad
And,
appeal
and
number
what is this?
44 of the-
1 second. What is this order at page 26?
Page 26. Page 26. That 3,000 have, 5,000 has become 3,000 before that order was,
But you were also paying the said enhanced amount. After the order passed by the district judge, he is now paying 3,000. What is this submission at page 27?
which one?
Page
Sorry.
27.
Page 27?
Hmm.
Yes. I'm reading from the beginning.
Yes.
It is submitted by Tishon Learned Counsel for the petition that the petitioner has already obtained decree of divorce on the ground of desertion by judgment and order dated so and so. It is further submitted that as per the order of MR case number 1, petitioner is paying rupees 3,000 per month. Accordingly, learned judge Baksa, while passing the order of the decree of divorce, also refrained from passing any order on permanent alumni and directed to continue to pay 3,000 per month. That is their lordship. That is from the
You read.
3,000 per month as maintenance to the respondent. However, by the order dated 2/5/2019, on the basis of a petition filed by the respondent 127, that is the announcement petition filed by them. The maintenance amount was announced to 5,000. Yes, Lordship. That I was referring.
Yes, you read.
Per month, and the petitioner was also paid.
Petitioner is you, right?
And yes, I was paying. At some time, I was paying
Correct.
5,000.
Now read.
As petitioner was paying the said enhanced amount of maintenance. However, after the order passed by the learned district judge Bajka, he is now paying 3,000.
Read.
3,000 per month. Accordingly, it is submitted that till disposal of the present petition, the present petitioner is ready to pay 3,000 per month as directed earlier by the learned judicial magistrate first class as well as learned district judge Baksa. Considering the submission
Then
made by
this
the learned.
court have directed that pending disposal, pay 3,000. What happened after that?
Thereafter, Lordship, this case in fact was listed,
It's still pending.
it's pending.
So this order is still going on.
Right.
And then
And then Lordship, this, They have
This-
come up with a permanent alimony
No, no, this order of distress has come because you have not paid the,
that maintenance alimony lodged.
no, that maintenance allowance,
Alimony part.
aluminum
ref-
part.
They have referred huge amount, no, Lordship. So 5 lakhs has been passed in alimony.
No, but that is, and that you have challenged. You said it was sub judice.
Yes.
Where? Which-
Lordship, I'm placing that. Page 36, Lordship. Page 36, Lordship.
Hmm.
This is matter appeal order.
See, it was,
Because this is
it was.
hard MST, Shom London Council for the appellant. Present appeal has been filed under section 20 of the 28 of the Hindu Marriage Act 19 against the judgment and order dated 3/9/2024. passed
By
the-
this order, it was directed to pay alimony.
No, not, nothing was said.
The
Lordship,
3924 order? The appeal is against the 3924 order.
Yes.
Where is
Time was directed to pay alimony.
correct?
But-
And there is, but no stay has been given.
No
Then-
stay has been given that the ship, then we challenge that order before this honorable court.
Where is that?
That is, I'm referring page 36, Lordship.
36 is not this court's order. 30
Yes, Lordship, this court's order.
This court, 36,
37. Yes, Lordship.
36 or 37? 37.
36 is a tight copy since it was not,
Yes, but where is the stay?
no,
Where is the
no stay
stay?
was granted, Lordship.
Then,
No stay was
then-
granted.
then how are
Notice
you
was
not
issued.
paying if there is no stay?
Lordship, that is a huge question of,
It is not, you, Ms. Som, you have challenged the order of 39/2024, whereby you were directed to pay alimony. Correctly, not correctly, that is not before this court. You have taken that matter before the High Court. The High Court has already issued notice and called for the record, but where is the stay order of 39/2024?
no stay was
So
granted.
until and unless the stay is given, just because the matter is sub judice, you will not be liable to make the payment.
My lord, that is, my lord, I am not avoiding my,
No, no,
Lawful
Ms.
duty,
Som, I'm
Lordship.
sorry.
my lord, I
That
am
cannot
not
be,
avoiding.
that cannot be. You should have obtained a stay order from that court. In fact, you could have also filed an IA before that court where the appeal is pending. You could have done a lot of things. You could have tried and obtained a stay. Unless that order is stayed, why should this court now interfere with the warrant of arrest which has been issued?
In that case, Lordship, let me have instruction.
No, what instruction? I don't find any merit in this case.
Lordship,
I can dismiss it.
I pray for Lordship because dismissal will amount to this, it will hamper in the bad.
Upon some determination of the petition, MS Som, learned counsel for the petitioner, seeks accommodation in order to obtain instruction in the matter. Prayer is allowed. You withdraw this, there is nothing in this matter.
Lordship,
Prayer is allowed. List after vacation continue.
I'm deeply obliged.
May please your lordship, and this is an application under section 528 of the of BNSS, my lord. Here the order we have challenged is the last
Chaudhary, which order?
at page 24, my lord.
Page 24.
Page 24.
Yes.
Learned Soins is accused Rahimuddin is present, accused Ambia Khatun is absent.
The available warrant.
Yes, my lord, the PNA, my lord, against your lordship may kindly say remaining persons are absent without any steps. Issue BWA of ₹500 against accused person Habibur Rahman. Issue PNA against the remaining accused person. The petitioners are the remaining accused persons, my lord.
Issue
That-
PNA, okay.
Yes, my lord. That is, their accused number was 5 and 6, my lord,
Yes.
as per charge sheet.
Notice can go, but
My
I'm
lord,
not saying anything
It
here.
will appear, my lord. Next date is 23rd of May, my lord.
Respondent is not, notice is not yet issued, yes.
One thing also I would like to point out, Lordship, that this Sarchit has been given also, Sarchit filed on Lordship 30/11/2017. And the order annexed here is only Lordship 1/3/25.
My lord, they did not appear for 5 days. I have the order sheets, my lord, certified.
Anyway,
copy.
I'm just issuing notice, nothing more than that. Heard MS SB Chaudhary, learned counsel for the petitioner, also heard so and so for APP Kurdiba. This petition is directed against the order dated 1/3/2025, whereby PNA was issued against the petitioners. In GR case number 1186/2026, passed by the Judicial Magistrate First Class, Mojai, Shankardev Nagar, Assam. Issue notice returnable 2 weeks. So and so accepts for R1, registered post AD, steps 3 days in respect of R2, list after 2 weeks. On date to be fixed by date.
Of the TCR.
And here, but the appeal, scan copy. Let the scan copy of the TCR be called for. So,
Along with the
by the
CD.
registry,
Along with the city.
along with the CD.
My lord, I may be allowed to file additional affid whereby I'll annex the 5 orders on which they did not. agree.
Whatever you want to find.
Yeah, I need to be honest. He said that, he said that.
Charge sheet and proceedings.
I take to apologize. There has been a slight inadvertent mistake, Your Lordship. The date of Your Lordship, in page number 43, Your Lordship.
43.
Yes, Your Lordship. The transmitted copy, Your Lordship. The date should be read as Your Lordship 03/07/2017.
Where,
In the
where?
first line, Your Lordship. With due respect, I would like to.
You
bring
make
to your-
this correction.
Your Lordship,
Enake correction to prove payment. Prove,
and original one is okay, Your Lordship.
enake prove. You have yet translated copy to. But we cannot make the correction like this now.
The original copy is okay, Your Lordship. Just,
I understand,
of-
but there is a way of making it.
With the function of with the permission of the court, you can. Faculty errors. The main copy is jealous. Certificate copy is jealous.
This which date?
First line.
3/9/19.
yes, Lord.
That should be,
It should be 03/07/2017, Your Lordship.
right, you make this correction and you put your initial.
Your Lordship, subsequently in,
So many
page-
corrections.
no, just another one, Your Lordship. In page number 8, similar, that thing only, Your Lordship. Paragraph 6, subsection 1.
Paragraph,
Paragraph 6, subsection 1. In page number 8, Your Lordship.
yes, that same date,
That's it, Your
3/9/19.
Lordship.
And you make this correction and we'll take it after some time.
Like,
This prosecution has been filed challenging the criminal proceeding.
You are Mr. Gore.
I'm appearing on behalf of J.C. Gore.
Yes.
First, this crossing petition has been filed challenging the order dated 13/11/2024 passed in NIA case number 56/2024
Cognizance.
at Boko.
Cognizance order.
Cognizance order and the criminal proceedings of the Boko court. Lordship,
138 proceedings.
138 proceedings of the NIA.
Notice.
Lordship. Lordship, may I place my text before this court, Lordship. Lordship, Lordship, for which the NIA case was instituted, basis on the agreement, which is on page 29. Lordship, may kindly come to page 29 of the petition. Lordship, the signs were taken by forcefully from the petitioner. On blank pages.
Not
and
at this
on
stage,
blank
we
checks.
cannot presume all this. There is
Lord-
a
Lordship, if-
presumption against the person who has signed, how it has been signed, how he has signed. Can this court now go into at the stage of
Lordship, for-
cognizance?
Lordship, for the
See, I don't know, even in the earlier case, so much it was submitted that at the stage of taking cognizance, the courts are not required to weigh the sufficiency of the evidence. What the court is required to do is to see whether the materials that has been collected by the prosecution is, even if it's taken to be correct, whether a sufficient case is made out or not to
Lordship,
carry on.
prima
That's
facie
all.
is a- it
Now,
has to
whether
be
those,
appeared.
how can the court look into the defense at that time? These are things which has to be considered at an appropriate stage of the trial.
Lordship, but prima facie, it has to be appeared that there.
Prima
the
facie,
case has
your
to be made out.
signature is there.
Lordship.
Your signature is there. Then,
But the signature was taken.
and a
forcefully.
presumption will be there.
And Lordship, for that, we had filed a civil suit in Amingao Court.
You
Before
see,
filing of
now,
the
now
NI
that
case,
is what I am
Lordship.
trying to tell you, that whether this is correct, not correct, can this be looked at the cognizance stage? These are, they will be looked into at the stage of trial.
Complaint proceeding, Lordship, there is a initial depositions at the end, Lordship.
Correct. And that presumption is there.
Lordship, for which the NI case was instituted, we had replied
Only
to the
notice.
letter issued by the advocate.
Notice. Heard Mr. JC, sorry, your name?
My name is D Cycle Lordship.
D cycle. Heard Mr.
Lordship, my
D.
humble prayer, one humble prayer, Lordship, kindly the NI case may be stayed for intent.
No.
Interim may be granted, Lordship.
No. Heard Mr.
D Cycle.
D. Cycle, Learned Counsel for the petitioner. Yeah. Also heard so and so APP. This is an this petition is directed against the order dated 13/20/22,
13/11/2024.
page 15.
Lordship, typographical mistake.
13,
13/11/2024.
2024.
Lordship, it is in page 41.
Whereby the jurisdictional magistrate court has taken cognizance against the petitioner under section 138 NI Act in NI case number 56 of 2024. Issue notice returnable 3 weeks. So and so accepts for R1, registered post AD, R2, steps within 3 days, or extra copy to within 3 days. Take steps. List after 3 weeks on a date to be fixed by the registry.
File your please.
May I please, Your Lordship? Lordship, such stated matter under section 379 and 411 of IPC. Lordship, in this case, the petitioner has failed to appear before the honorable court. Lordship, may kindly turn to page 27, Lordship. Order dated 6/12/2023. Since then, the petitioner has failed to appear,
You
Lordship.
appear. Why are you not appearing?
Lordship, actually, the fact of the case is such that the petitioner lost his contact with the.
That cannot be a ground. A criminal case is pending, and this is how so casually criminal cases are being attended. You will not even keep in touch with your lawyer. You will lose contact and you stop appearing. And then the moment the warrants are issued, you will come running to the High Court to get a stay. This is not how criminal matters can go on.
If the petitioner is willing to appear, Lordship.
Go. You appear then. Who's stopping you?
Lordship, a direction may be given.
What direction?
Lordship, the last order.
Such conduct cannot be taken so lightly. It is becoming a routine manner.
Lordship, the petitioner.
Criminal matters cannot be treated in this manner.
A last chance may be given. He's a financially very poor person, actually, Lordship. for which he could not engage a fresh counsel. And could
Legal
not
aid
get-
councils are there. Please don't make that kind of a submission before this court. No accused will be heard without their lawyer. Any problem?
Lordship, in the last order, the petitioner has been declared as the proclaimed absconder, Lordship.
Rightly so. What is wrong? And why should this court keep on, because if this court keeps on interfering with these kind of orders, there will be a time when the trial courts will stop doing it. Then how will the trial be concluded? You will not appear. Sorry,
Lordship, from now on, he'll appear regularly.
you babe, I am only issuing notice. Heard, MS?
S. Yasmin, Lordship.
Sorry,
S. Yasmin, Lordship.
S. Yasmin,
Yes.
Learned Counsel for the petitioner. This so-and-so APP. This application, this criminal petition is directed against the order dated 6/12/2023, 25/6/2024 and 21/9/2024 and all subsequent orders whereby Learned Additional CJM Morrigaon issued and reissued BWA and NBWA and PA against the petitioner in connection with PRC case number 76/2022. Stop. Issue notice, returnable 3 weeks. Accepts notice for the respondent. Nothing is there. It's becoming a routine manner.
Under the here, yeah, when the issue, they will come.
Extra copies, so and so are list on such and such date.
Yes, Lordship.
Number 50.
Yes, Mr. Chaudhary.
Yes, my lord. My lord, in this case, my lord, the respondent, my lord, authority, my lord, has sorry, my lord, prosecution, the investigating officer, my
It
lord.
will take some time. Otherwise, I'll come back in 5 minutes.
Yes, my lord. So what happened, my lord? That, my lord, I filed an FIR, my lord, before the, my lord,
Who filed an FIR? You.
I meet my client, my lord. Yes, sir. Victim girl, LS victim girl. LS victim girl has filed, sorry, ma'am. Victim girl has filed an FIR before the officer in charge of the school police station. That allegation is that the one of the accused person, my lord, has committed rape to her, my lord, and my lord, by using predatory practices, and my lord, the accused person has dominance over me, my lord, because I am his franchisee, my lord. So, my lord, due to that, my lord, repeatedly she has committed, my lord, rape to me, my lord. Subsequently, in the year 2022, I filed an FIR. Thereafter, my lord,
Instructions.
Wait,
Item number 28, your lordship.
criminal petition.
Yes, your lordship.
Any stay operating?
Yes, your lordship.
Uh, you are for
I'm for the petitioner K. Parvati. your lordship.
28.
20.
Your name is not showing.
My name is not shown. J. Ravas.
Are you sure this is the one criminal
Yes, K.
petition?
Parvati. your lordship.
Mr. E. Deori, Learned Counsel for the petitioner submits that he has received instructions from the petitioner not to press the instant criminal petition and accordingly seeks withdrawal. Prayer is allowed. Criminal petition stands dismissed on being withdrawn. Also put the appearance, Harder. What's the TDOD? Mr.
I am A Hussain.
MD A.
Legal
Hussain, Learned Legal Aid Counsel for the respondent and law court for APP. Disposed of.
Obvious. I'm very grateful.
Yes.
Previously in regard to,
The offenses are 506
yes, your lord,
and
294,
506 is threat, criminal intimidation.
yes, your lord.
506.
Your lordship, kindly come to page number 72, your lordship.
1 second. And what is 294?
294, your lordship, obscene language, your lordship.
Let's go to the
Obscene acts and songs. Your lordship,
FIR, let's go to FIR 43.
yes, your lordship.
The threat is not a mere threat as it appears from the FIR. And what is the charge sheet?
Your lordship, charge sheet is at page number 48, your lordship.
See, the difficulty is that it is not a case that you're right, 420 perhaps is not there. But it cannot be said that no criminality is there.
Your lordship, I would like.
I
to-
can issue notice, that's all. I'm not going to stay the proceedings.
Your lordship, kindly come to page number 73, lordship.
I have heard you. Page number 73.
72, your lordship, annexure 11, your lordship. This FIR was lodged in the year 2019, your lordship. There has been 2 years delay, your lordship.
Mr.
Again-
Counsel, these are, ultimately, these are factual aspects. This, please don't change the, you see, at the time of cognizance, the magistrate courts cannot go into all the detailed inquiry and all that. It has to prima facie be satisfied with the facts, the circumstances, material that is collected by the investigation officer, the statements, and see if an offense is prima facie made out or not. Now, threat and all these allegations are there. Whether those allegations are correct, not correct, that is not going to be seen at the cognizant stage. Now, if you are right, 420, but that apart, it is not a case that no criminality whatsoever is made out.
Sure.
The threat and everything is there. I'm issuing notice.
Lordship, your lordship, it is to, your lordship, I have to say, in page number 72, your lordship, actually, the petitioners has previously lodged an FIR, your lordship, against the respondent number 2 and some other associates.
I am not dismissing your criminal petition.
Your lordship.
I am not dismissing your criminal petition. I'm issuing notice.
Lordship,
These are matters which has to be heard after the after the respondent number 2 appears. I'll keep your interim open.
Lordship,
Nothing doing, sorry.
at least, your lordship, petitioner number 2, your lordship, she has been suffering.
Sorry.
Your lordship,
Mr. Datta, you are Mr. Datta or Bormon?
A doctor.
Heard Mr. A, huh?
Regarding lordship, staying the proceeding regarding the petition number 2, lordship, that is not required, lordship, because if he is not able to come to the court daily, lordship, there is other
Uh,
procedures also there, lordship.
Heard Mr. A. Datta, Learned Counsel for the petitioner, also heard Mr. E.S. Locker, Learned APP for the state respondent. This criminal petition is directed against the order dated 22/8/2019 for taking cognizance against the petitioners under section cognizance and also the order dated 27/9/2022, whereby charge was framed against the petitioners under section 294, 420, 506, and 34 IPC. let notice be issued. So and so accepts for R1 and registered post AD. R2 extra copies within 3 days, steps of 3 days. List after 3 weeks on a date to be fixed by the registry. And the interim prayer shall be considered after the returnable date. On the returnable date. Let the trial court, let the scan copy of the trial court records be called for by the registry. Interim to be considered after receipt of the trial court.
Okay.
Mhm. Uh, Okay, I think I'll have to appoint someone for the appellant. And it's a POXO. We appoint someone and also issue notice. None appears for the appellant. No, sorry, don't say that. This appeal is this criminal appeal is filed by the appellant from jail. Mr. Nimesh Mahajan is appointed as an amicus curiae to represent the petitioner, appellant in this criminal appeal. Let registry supply a copy of the appeal along with other documents to Mr. So-and-so. And list after after vacation of the daily list on such and such date. Let registry reflect the name of so-and-so, let amicus curiae in the cause list. Why is it? This is
My lord, against
criminal
equity
appeal.
lawsuit, under section 413 of the
This
PNS.
Statutory appeal,
Yes, lord.
admit it.
But
Appeal is against
that is
acquittal.
statutory appeal laws.
Against acquittal, leave has been taken. Leave is not required.
My lord, leave is not required as per the Honorable Supreme Court judgment lawsuit. Okay, my lord, April 2022 live law SC 83. Paragraph 10.2 laws. No special leave is declared lordship for filing a bill under section 430. That was for
Under section
my lord,
372.
yes, lord. Now it is my lord 413 lordship, PNSS lord.
You have a look at it. I'll take it up after the
10.2.
orders. You wait for a while. Have a look at it, Mr. Locker. Yes. Yes, Mr. Chaudhary.
Wait, your lordship.
Why is this for orders?
It's come for orders because after a long deliberation, the copies could be served to the concerned respondents in item number
Mr.
20.
Gaur, you're appearing for the respondents.
Appearing item number 20, I'm appearing for JC Gore. In item number 21, I'm the petitioner. Appearing on behalf of JC Gore.
Okay, sorry, your name, you are Soikya.
I am DC.
Yes, this Soikya, right? You're appearing for all the respondents.
I think they will be appearing for respondent numbers 1 and 3.
1 and 3. And two,
Two has passed away. There is a judicial order.
and two has passed, and four is state. So basically, 1 and 3 are appearing, right? So this matter can be,
Fixed for admission.
it has not yet been admitted.
Oh, your lordship.
Mr. D. Soikia, Learned Counsel, enters appearance on behalf of respondent number 1 and 2.
1 and 3.
1 and 3.
In fact, in the Lozima order
It
also.
says, but that time, also that time also someone had appeared. It appears that the matter is ready for admission. Let the matter be posted for admission,
Would it be on 5th of May, your lordship?
5/5/2025. Please put the appearance, Mr. A.K. Chaudhary, Learned Counsel appearing for the petitioner, Mr. D. Saikia, Learned Counsel appearing for 1 and 3, and Mr. So-and-so APP for R4. The arraignment is same in respect of 21.
Same.
So put 20,
Arising out of the same.
20 and 21 together.
In that other matter, will be appearing for the respondents. That 401.
Together Puripela তুমি এনেকে কৈ দিয়া A.K. Chaudhary to petitioner কৈছা নহয়, stroke R2 কৰি দিয়া আৰু D. Saikia to R1 and 3 কৰি stroke petitioner কৰি দিয়া. Correct?
For respondent number 2, Chain Enterprise.
Yes.
And
Or like it is a full matter is now ready for hearing. No, admission, sorry. 29. 20.
May be the lordship.
Yes.
My lord, it's other than your lordship, I heard in part, my lord. It's a case, my lord, where charge sheet has been laid under the NDPS. So, my lord, if your lordship first takes up the Constitution of India, my lord.
This matter is not আজি তো বেল বাকিবোৰ দি থকা নাই, এইটো বেল ইয়াত দিলে যে আজি। Anyway, I'm not, this seems to be the only bail which has
Yes,
been
sir.
given before this court, but this, otherwise it's not tied to this court.
I have. In fact, it came on Monday, my lord, before.
That date I was taking
Yes, ma'am.
bail as well. Anyway, I will look up for it. Criminal bench control December. Okay, yes.
My lord,
This is that NDPS matter.
NDPS matter, my lord, where I am for bail, this petition is filed, my lord. Only on 2 grounds, my lord. Well, first of all, my lord, Article 22(1) has not been followed of the Constitution, my lord, where it says, my lord, no person who is arrested shall be detained in custody without being informed as soon as may be or of the ground for such arrest, nor shall he be denied the right to be consulted and to be defended by a legal
Any
practitioner.
NDPS bail matter where the court have granted bail for violation of Article 22?
Yes,
You have?
yes. Yeah. Well, before that, my lord, can I point out, my lord? NDPS, my lord, 37, there is a rigor, my lord, there is a power, my lord. So far, my lord, NDPS is concerned, section 37 is there. And my lord, there are 2 other acts, my lord, where it is, my lord, Unlawful Activities Prevention Act, my lord. There are also 43D(5), my lord. It's the same. And moreover, my lord, the PMLA Act, my lord. There also, my lord, 45, section 45, same as section 37. Same as section 37. It's there, my lord. There is a bar, my lord. So now the question arises before your lordship on the last occasion, whether due to section 37, bail can be granted on. That's the
But
core issue.
isn't this a factual aspect?
No, my lord.
Why?
My lord, where the Supreme Court, apex court, my lord, the last occasion
That is Kejriwal's case,
no, that is, my lord, Probirpur case.
but that is in relation to what
A
offense?
unlawful activities. Unlawful activity. And recently one judgment came, my
So-
lord, That is, my lord, Subhash Sharma, my lord. It is with regard to PML, where bail has been granted.
What do you have to say, Mr.
My submission is that lordship, regarding lordship, to be protested, that is ULP Act.
Yes, you.
ULP Act lordship. And in some cases also, we have to see that the motive of, let's say, Article 22(1) lordship. There are some cases lordship that lordship, wherein it is stated lordship that,
My lord, lordship may take up
Why
the seven.
Yes,
Seven, my lord, it's a Subhash Sharma. My lord, it's a case, my lord, PML.
no, this is at serial 7, it is Joinal Hussain.
Oh, I'm sorry, my lord, 999. I'm really sorry. 9.
9 is Subhash Sharma. Yes,
My lord, it's a case, my lord, where it's a case between a Director of Enforcement and Subhash Sharma, my lord, where the High Court has granted bail because not following the Article 22, my lord. Thereafter, my lord, Director of Enforcement came before the Supreme Court on appeal, my lord, and that appeal was dismissed, my lord. It has held, my lord, it was correct, my lord. Paragraph 8.
under the PMLA Act, this is,
PMLA.
it has a similar structure.
Same, my lord, section 37 ditto, my lord,
So-
PMLA.
PMLA Act, concern. But here is not about, this is not a case where the ground of arrest was not set. The facts of this case, Subhash
lord.
Sharma. Read the Directorate of Enforcement.
In paragraph 8, my lord, it says, once the court, while dealing with the bail application.
No, that I have seen.
Yes.
The finding of fact recorded in paragraph 2 is 10 is that undisputed. Please read that.
Yes, my lord.
Because this observation is in the context of this case, correct?
My lord. Yes, but I have other cases also, my lord. Well, yeah, I'm just.
And
showing that,
30, what is the section here?
section 45 of the PMLA.
Which is the other case?
Now, my lord, now lordship, our High Court, my lord, is the serial number 6, my lord. Mofizul Islam, my lord, 6. Paragraph 13, my lord,
This is NDPS.
NDPS. Second paragraph, my lord, this is an application under section 483 of the BNSS, my lord, praying for grant of bail to the accused who has been arrested in connection with special NDPS case number 5324 under section 22C. C is commercial law. The relevant paragraph, my lord, paragraph 13, my lord. It is in the instant case also, as discussed above, it is seen that there is no mention of grounds of arrest in the notice issued to the present accused petitioner under section 47 BNSS and accept the same name, address, and the case number. There is no mention about any other particulars of the offense as well as the grounds of arrest. so far the proviso of section 47 of the BNSS, it is seen clear, seen that if there is clear violation of mandate of Article 22(1) of the Constitution of India. And in such case, in spite of the statutory restriction under section 37 of the NDPS Act, the court is of considered opinion that for the violation of the constitutional mandate contained under section 22(1) of the Constitution of India, the arrest of the petitioner is vitiated and it may be a sufficient ground to consider her bail application in spite of rigor of section 37 of the NDPS Act.
Yes. What was the second ground?
My lords, I have gone to the LCR, my lord. So far CRPC is concerned, my lord, section for 50 and 50A, my lord. First section, my lord, the grounds of arrest should be communicated to the accused person, my lord. The second one, my lord, to the family member of the accused, my lord. In the instant case, my lord, I have flag marked to the LCR is here, my lord. To first, although they have given the application, the notice under section 50 to the accused, grounds of arrest is not mentioned. And while communicating to the family members, there is a simple note, it may be communicated to the family members, but it was not communicated at all.
Yeah.
Follow. You confirm it.
Is it grounds of arrest is there?
Petty lordship. Specifically, that ground of arrest is not mentioned. So it is mentioned you are hereby informed through this notice that you have been arrested in connection with the above referred case and will be forwarded to the court in the offense non-bailable to police. You may submit petition before the honorable court for a bail.
Is that not sufficient?
No, my lord, I think not, my lord, because the grounds of arrest and the reasons of arrest, my lord, it has been discussed, my lord, in that, my lord, number 2, Vihan's case, my lord. Vihan's.
Lordship, can it be taken up on day after tomorrow? Because some other cases are pending here also in fixed and day after tomorrow.
Day after.
Day after tomorrow.
But you see, in that case, you check up the TCRs because your one ground is ground of arrest not mentioned. And second, the family members have not been intimated as per the procedure.
Yes.
And
Those two
are the main
those two are
ground.
the main, my lord.
Okay. Now you verify all that. Yeah, and you flag it, Mark. And Mr. Doctor, in case one page note you want to give, you can give it on that date.
Okay.
It will help me to
Fine.
dictate the judgment.
Fine. Then that case law may be there, my lord. in the-
Yes. I'm keeping the case
Yes,
law.
yes, fine, yes.
In your note, you
Fine.
can just refer as these decisions that you are on which points,
Fine.
paragraphs, and a small note, whatever you want to say.
Only your lordship, my lord, for my satisfaction, my
Yes.
lord, my lord, this is the notice.
No, that he's read, I've heard.
Yes,
that he wants to probably let him do it. Kindly inform to the family.
that information.
I don't think you verify this. Because you see, the constitutional fundamental rights violation, that will not be narrowed by 37. 37 of the NI Act NDPS Act cannot curtail that fundamental right, isn't it?
And I have given a series of our high court.
If it was a case where they are alleging violation of the procedures of the NDPS Act for search and seizure, then of course these are factual issues which perhaps which can be raised during trial, and these are not grounds for which a bail can be granted, because NDPS grounds on which a bail can be given is given in 37 when it's commercial quantity, correct? But here the argument is violation of Article 21.
The other points are also there, my lord, but I am not arguing on that. point,
Mr. Doctor, you put all the points.
my lord, and the paragraphs of the each cases.
Yes, just put the points.
One more thing, my lord, we on academic discussion, my lord. There are 37 numbers of small packets have been seized from the petition, from the accused petition. And what the magistrate did, my lord, mixed up all everything, my lord. Then they have drawn a sample. It cannot be, my lord.
You take all the points that
Right.
you want to bring. Usually it will, because at this moment I'm inclined to grant you the
My
bail,
lord, my lord,
but that's why I'm asking for more handles.
my lord, my lord,
Uh,
my lord.
Because ultimately you see, 37 is very clear.
Clear,
Isn't it?
Yes.
And Justice Chandrachud's decision is also there,
Yes,
but
I
of
know,
course,
my lord, yes.
in that Article 21 was not taken note of it. What was taken note of is that those Section 42 and all that of the
Yes,
NDPS Act, where the seizure and search is procedural violations, where the apex court have said that these are factual issues. And it can be taken care of during the trial, not at the stage of granting bail.
Yes.
And the only test is to see whether guilty or not guilty,
Yes, guilty or not.
reasonable ground. That is the only
Right.
test. That has been laid down. That is where I'm finding a
Can I
little
make a small
difficult.
synopsis, ma'am? I'm obliged, ma'am.
Relist when?
Friday tomorrow.
Friday. Yeah. Friday. कितनी पुणे दिसलं?
Thank you, LCR. I'm obliged.
Yes.
I have seen it.
Judgment is at best 14 years.
The 413 is old under the CRPC. It is 372.
CIPC 72.
370.
413 law.
72.
Huh?
72.
372. 413 to some. Yeah.
And
Yes, please read.
413.
no appeal shall lie unless otherwise provided. No appeal shall lie from any judgment or order of a criminal court except as provided for by this Sanhita or by any other law for the time being in force, provided that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offense or imposing inadequate compensation, and such appeal shall lie to the court to which the appeal ordinarily lies against the order of conviction of such court.
So in case of victim, there is no leave required.
And there also was that was required because of some judgments also. Actually, incorrect.
This appeal heard Mr. M.H. Ahmed. Learned counsel for the appellant also heard Mr. Solar DPP. This appeal is presented against the judgment and order dated 22/2025 passed by the learned session judge Lakhimpur, North Lakhimpur in session case number 147 within bracket NL 2022, whereby the accused respondent number 2 was acquitted under section 302 IPC. This appeal is presented by appellant is the informed by the victim. Is the victim.
My lord, he is the elder brother, my lord, as per definition, he is the victim.
Huh?
As per CRPC definition law, she is the victim law.
How?
Elder brother, in absence of my lord, father is a guardian lordship.
Guardian and victim is different,
Right, it includes lordship,
is it?
victim lord, definition of victim lord
Please
is,
find out.
my lord.
Let me issue
CRPC
notice and keep right now. We'll issue notice. Returnable 2 weeks. Data number 1 and registered post for 2. Huh? 213
Victim means a person who has suffered any loss or injury caused by reason of the act or omission of the accused person and includes the guardian or legal heir of such.
So I am the elder brother lord and informant lord.
and victim is a child. No. No, even any elder brother.
That elder brother not is not mentioned, was it? Guardian or
Legal here.
legal heir.
So it includes lordship, the elder brother or relatives, family members.
I have my doubts. Anyway, the issue as whether the appellant qualifies as a victim in terms of the definition under section
1A, sorry, 1WA.
1WA
Of the CRPC.
of CRPC is kept open, where it shall be considered on the next date. Notice issue. Steps by registered post agent in 3 days. Huh? This stuff is mentioned.
Of like that.
At this side,
Other side.
they are not there today.
Not
We'll
done.
have it after the vacation then. They're not there.
They may not.
Last time, on your behalf, the adjournment was granted. Heard Mr. A.R. Sikdar, Learned Counsel for the appellant. Also heard so-and-so PP, and none appears for the respondent on call. List for hearing. The date of reopening up. None appears for the petitioner on call. Heard so-and-so and relist. Did you date? Next. Yes, Mr. Sharma, you've been waiting for a long time.
That your lordship remembers that whether informant is required to be included, that I have checked my lord, last year, there's a notification that it was removed. From 14 to 24, it was required. Now from 24, it is not required. The lordship was fine.
So this matter has to be, this matter was, I have actually forgotten what the matter was.
Your lordship has not heard.
I've not heard this matter. After as list for hearing appears to be Mr. M. Sharma Arohi, list for hearing. Date. When do you want it, Mr. Sharma?
But except 24th of February.
Am I-